Greetings, class. We're here, Criminal Justice 315. We're doing some more criminal evidence here today. We're on Chapter 12 today. We're talking about field interviews, arrests, and jail searches. I want you to know up front, real quick, here's what we're going to talk about. We're going to talk about the right to use force, and we're going to talk about field interviews, and we're going to talk about pat-downs. But when it comes to jail searches and inventory searches, stuff like that, that's going to be on your own. You're going to need to touch that on your own. I'm going to try to get in these topics a little bit more, but you're going to see all this stuff again. All of it, even the stuff that I don't get to touch on, because I only have a limited amount of time and I don't want to take up all your time here today. So, right to use force. How do you know, how does the police know that they have the right to use force? Well, you have to engage in the analysis that we kind of talked a little bit in the previous chapter. And that analysis is, well, if I'm going to use force, that means I'm going to be seizing this person. I'm going to stop them. And I may not necessarily search them. I'll search them after I use force to stop them. But using force means I have at least at a minimum seized them. I may search them, I don't know yet, but I have at least stopped them. All right, so now we talk about, all right, I have seized them. What level of suspicion do I need to seize someone? Well, the first thing is that you can have reasonable suspicion to conduct what's called a Terry stop. And that's a little bit after this, but I'm weaving in a couple of paragraphs later into this first part that talks about right to use force, because that's how these two come together. So if I'm going to use force, I first have to seize them. And in order to seize them, I have to have some level of suspicion. And that suspicion can be reasonable suspicion, which is on a Terry stop. But the problem with a Terry stop, as you learn later on in the chapter, is that it's only for a limited amount of time. I don't really know if I have enough time. I don't have enough justification on a Terry stop to use force, because force implies that it's going to be more than just a stop. It's just more than a seizure. So I probably need probable cause to actually use force because of the amount of force I'm going to use. I'm going to be doing a lot more if I'm an officer. If I'm using force, I'm not seizing necessarily per se. I'm doing seizing plus something more. So I probably need probable cause. What do you need probable cause of? Well, probable cause that the person, it was more likely than not the person committed a crime, more likely than not that evidence of a crime can be found, or the fact that maybe you actually saw the person commit the crime and you got probable cause. And there's different levels to all this, but nonetheless, you're probably going to need probable cause, more likely than not standard, to use force. Now, we have approached a situation where we have probable cause and we have a right to use force because maybe the suspect is running away. What do we do now? Well, you have a right to use force if you have probable cause to make an arrest. How much force? The book says it. It's the legal world's favorite word, reasonable. You have the right to use reasonable force. So, if you are using reasonable force, it has to be reasonable to what? What is it? Is it reasonable to, all my experiences? No. It's reasonable to the certain circumstances you're in at that time, which means reasonable to the crime that you believe that person committed. It's the best way I can describe it. That means if the person running away, you saw them shoot someone, well, you probably have the right to use deadly force. If you saw that person shoplift from the local sheets, well, you don't have the right to use, deadly force. You have the right to, maybe tackle them. Do you have the right to tase them? Maybe not. You're getting to a gray area there. I mean, if it's a candy bar, it's a 16-year-old child, and that's evident, probably not. But if it's a heist, hundreds of thousands of dollars, if it's a couple hundred dollars, these are facts and circumstances that are going to determine whether or not you can use a greater level of force. But you always have to remember that the level of force has to be reasonable to the crime that's being committed, or which you have probable cause to believe has been committed, or probable cause to the evidence of crime you believe. Because you probably, for example, you're on a stakeout and you're investigating a local crime rig going on, and you notice that there's this car that drives in, and you see 10 or 15 brown paper bags taped together with duct tape and little blocks like this, and you see them all being stuffed in the trunk of a car, and you kind of know at that point, you know what that is. You don't know if it's a specific drug, but you know it's probably a drug. At that point, you probably have probable cause to to arrest, not necessarily arrest, because you don't know what it actually is, but you have probable cause to search that trunk, determine what it is. But if they don't stop and they start driving away once you flip your lights on, Well, you may have the right to use force. What? Maybe run into the back of their wheel, kind of make them do a spin out. That's force. That may be justified. It all depends. It all depends on whatever it is you believe the person that you're trying to stop or the things you're trying to seize or search. It all depends on those circumstances. Now, I want to talk a little bit about this field interview that your book discusses, and we talked about it a little bit already, the Terry stop. This is a police officer's favorite thing to do, and I cannot tell you how many times I have actually cross-examined police officers in the past, and this is how they always start. I had reasonable suspicion to stop. That's how they always start. And, I always liked when they did that because I really wanted to hammer home what they have to justify, because some police officers just have this idea that, I have reasonable suspicion to do anything, just about anything. It's like a blank check to them. And it's really not, because to have reasonable suspicion, you have to be able to point out facts that give you rise to believe that criminal activity is afoot, which is the way the U.S. Supreme Court said it in their case. So that means if I'm cross-examining a police officer and he's on stand, so you testified here today that you had reasonable suspicion that my client was the person you were looking for that you heard out on the intercom. Is that correct? And the officer is going to obviously say, yes, that is correct. I did believe that your client was the one that was being radio dispatched. Right. Okay, thank you, Mr. or Mrs. Officer. Isn't it correct that the description given was male? Well, that's correct. And wasn't the description saying that he was white? Yes. And wasn't the description saying that he was between the ages 18 and 30? Yes. And wasn't the ages, didn't you testify also that it was 11 o'clock at night? That's correct. And what was the area you were in? I was in downtown. Okay. So explain to me, Mr. Officer, where do you believe there was an actual crime committed? And he's going to look at me and he's going to be like, well, I don't know. I just saw a guy who matched a pretty blank description of who I thought believed crime. You just so happen to get lucky that it was my client that committed the crime. But the thing is that you didn't have reasonable suspicion to stop. You have to say, well, he was actually walking away from the scene of the crime. Okay, well, now you got me a little bit. Now I'm believing you a little bit more. I'm starting to think that there was reasonable suspicion that my client committed the crime or that criminal activity was afoot. But if you just say he matched the description, unless the description is very detailed, matching, going down to what the clothes they're wearing, to the hat that they're wearing, any special identifying markers, these are very important facts. But if you just give a general description, between 5 foot and 6 foot, between 18 and 30, black African-American male, and it's broad daylight, and we're in Atlanta, Georgia. That's not reasonable suspicion. Everybody's meeting that description. Half the population is going to meet that description. You have to be able to give, walking away from a scene of crime, was wearing a plaid shirt, was wearing plaid pants, was wearing Nikes that were black with a blue check mark on it, wearing a hat backwards, had a tattoo under their left eye. I mean, these things are important to identify. There are some other things too, like when you talk about reasonable suspicion, you talk about, it may not just be about the identification of the person. It might also be about what you observe the person doing when you're approaching. Take Terry versus Ohio. The people that were stopped were walking in front of this store off and on, looking very suspicious, as if they were looking inside, almost like casing it. And it was obvious that's what it looked like. Everybody would think that. Well, in that situation, the facts and circumstances at least allow, because they're easy to point to. You can point to them. And you can say, that looks suspicious. And you can say, I was allowed to get up there. I would go over there and stop them for 15 minutes and talk to them and ask them what they're doing, or, are they trying to find, something inside the store, or are they actually casing the place? You don't know. That's what the field interview is for. So you have to have reasonable suspicion, which is articulable facts that support a conclusion that criminal activity is afoot. That's the definition. And articulable facts mean articulate. You need to be able to point and say that fact and that fact and that fact and that fact all support reasonable suspicion. Now, just because you have reasonable suspicion to stop a person does not mean you have reasonable suspicion or probable cause to search. This is another area where officers kind of just think, once I've stopped them, I have a right to search them. Or people tend to believe, because they're scared in that situation, they get very fearful, they tend to believe that, yes, I have to let them search me now. So then they consent. But no, they need to be able to do the same thing again to search you or pat you down, except this time, if they're going to pat you down under the Terry stop, they have to be able to point to articulable facts again that show you're armed and dangerous. You have to be armed and dangerous. Those are very important facts. So if, let's just say, for example, Terry versus Ohio, it looks like I was casing the joint, and I was looking around. It looked very suspicious. What are you doing? It's 6 o'clock. That place has been closed for an hour. What are you doing, man? And I'm talking, oh man, I've been looking, for this one item, for my girlfriend, and we've been having a rough time, this, that, and that, right? And it's just a basic conversation, and my hands are visible, and I'm standing there, and I'm looking the officer dead in the eye, and that's all I'm doing, and I'm explaining my side. That officer has no reasonable suspicion to pat me down because my hands aren't in my pockets. Now, that's not determinative, but my hands aren't in my pockets. I'm not fidgeting. I'm not doing this. I don't look like I'm trying to reach for something. I'm not trying to hide one hand and, say, like, look at this hand, but don't look at what I'm doing with the other one. Well, I'm not doing any of that. So the officer can't just pat me down. And then once he does have reasonable suspicion, maybe I did look like I was reaching for something, or I had an interesting just appeal, my hands were in my pockets, or I couldn't listen. I wasn't following direction from the officer and what they were asking. Then the officer might say, I feel like you're armed and dangerous. For my safety, I would just like to pat you down. He can then only pat down, he or she may only pat down outer clothing to feel for a weapon. If he feels anything else but a weapon, if he feels my wallet, he doesn't get the search. He has to feel something that feels like a weapon. So that's a knife, that's a gun, that's anything of that nature. There's some gray area on drugs. I'm not going to get in there. This is not law school. I don't want you to go there. Just know that it's a pat down, and it's a two-step approach to get there. The first step is you first have to have reasonable suspicion to stop. The second step is you now have to have reasonable suspicion to do a pat down. And that's only if there is no probable cause. Now, I'm going to wrap this all up for you in a nice little rubber band for you, or not rubber band, or package for you. If you see on a question, you see a person making any sort of stop or seizure, first I want you to ask yourself, is this a government official? If it's not a government official and it's a private person, like myself, I'm a private person, and I'm doing the stopping or the searching, Constitution doesn't even apply. You don't even get to the Fourth Amendment analysis. Constitution only applies to the government. It doesn't apply to a private person. Number two, if you determine that you see a government official, number two, you need to ask, was the action done pursuant to a warrant? So, number one, we're going to start up here, this hand right here. Government official, yes. All right. Was the action taken done pursuant to a warrant? Yes. Test the validity of the warrant. Was there a neutral detached magistrate? Was it based on probable cause? Did it describe its particularity? Was it given under oath and affirmation? If you say no to some of that, what if you say it didn't necessarily describe with particularity? Does the good faith exception save the warrant? Okay. Let's go back up to the top. Was it a government official? No. Well, guess what? You don't go any further. You stop there. Okay. Your answer choice you need to find an answer choice that supports no. That's what you needed to show. And that's what you need to look for. All right, let's go back to the top again. If it was a government actor, yes. Was there a warrant and the facts? No. Well, then that is going to be whether or not was there a probable cause to make a stop. Yes. Okay. Keep justifying it. We're going to have to stop there on the probable cause part because we got more to come later on in the other chapters. But we can go, no, there was no probable cause. Was there reasonable suspicion to stop? Yes, there was reasonable suspicion to stop. Was there reasonable suspicion to pat down? Yes, there was reasonable suspicion to pat down. Then you need to find an answer choice that that does that, that satisfies that analysis. That's how it looks. And as we go along in the rest of the chapters, we're going to develop that little flow chart a little bit more so you understand, and I'll do the whole thing. I hope that works for you. If not, just let me know, and I'll try something else a little bit different. Anyways, that is the end of chapter 12. That's field interviews, arrests, and jail searches. Please remember that you are responsible for everything in this chapter and all the other chapters, and I look forward to seeing you the next time.